Welcome to Employment Law This Week. I'm George Whipple. Employers dealing with the theft of trade secrets or confidential information have a decision to make. Should they pursue the matter through a civil action or refer it for criminal investigation? That's the subject of this week's Spilling Secrets, Epstein Becker Green's podcast series about trade secrets and non-compete law, available on the Employment Law This Week podcast feed. Special guest, Epstein Becker Green's Daniel Levy. He runs down the many factors to consider in making this decision.
I think the most important item to consider is the type of information that has been misappropriated. If, for example, there's been a misappropriation of blueprints for a new product that the client is yet to bring to the market, that may be one example of a time that a client may want to consider referral for criminal investigation. Other items to consider include where the information may have been transferred, such as whether it went to an email account or to a cloud storage account. And finally, another item to consider is whether there is the possibility that the trade secrets may leave the United States or possibly have already left the United States. In that case, I would certainly recommend a referral to the federal government.
Dan highlights several advantages to criminal prosecution. For example, in some situations, the government has a better ability to recover misappropriated information than can be achieved through a civil lawsuit. Taking the matter criminal also involves potential savings, because the government is essentially conducting the discovery aspect of the case. In addition, a government referral can act as a deterrent for other employees who might engage in similar conduct. However,
there are some downsides. One is that in a civil litigation, we can work directly with our clients to develop a legal strategy and implement that strategy throughout the litigation. The other potential downside is the timing of any action by the federal authorities. There may be times where you ask the government to investigate, but they may not do so immediately.
An employer could speed up the government's timeline by preparing a written referral document. This document would provide a summary of the information authorities are likely to request, including exactly what has been misappropriated, the alleged actor or actors involved, and the value of the information. But there is one thing to remember about these communications.
I always advise clients that communications with the potential prosecutors are not privileged. While there may be an argument that early communications with the Department of Justice may be covered by the law enforcement investigatory privilege, we must assume that all communications will be discoverable.
He shares more advice on the Spilling Secrets podcast, including the role trade secret misappropriation plays in some of my favorite movies. You don't want to miss that. Thanks, Dan, and thank you very much for watching. We'll see you next time.